The judiciary sounds like something abstract, cloaked in black robes and legal jargon. But strip all that away, and the judiciary is a quieter, slower, but no less consequential power in our system of government. Alexander Hamilton put it plainly in Federalist number 22. He said, laws are a dead letter without courts to expound and define their true meaning and operation. In other words, laws need courts to interpret and apply them, and the judiciary is essential to making the law real, even if justice is sometimes left wanting. Let's play this out. Imagine a world without law. Does that sound liberating? No traffic tickets, no taxes, no one telling you what to do. But now imagine your neighbor wants your shoes or your car, or worse. With no rules, it's survival of the strongest. This kind of world would quickly reveal itself as less about freedom and more about trying not to get robbed or killed. Welcome to the state of nature. The state of nature is the proposition that while you can do whatever you want, so can the person standing next to you. There's no structure, no boundaries, no shared rules. So your property is only yours if you can defend it. Your safety is a daily gamble. In that kind of world, might makes right. And the moment you're outnumbered, you're outmuscled or outmaneuvered, the game is over. The odds will never be in your favor. Without law, there is only raw, brute power. And the people who lose first and worst in that kind of world are the vulnerable, poor, and marginalized. The judiciary exists because power needs to be restrained. Not just presidential power, not just congressional power, but the raw, everyday power of one person over another. Put simply, the judiciary exists to interpret the law, check the other two branches, and protect your rights. It is our constitutional referee. That's the ideal. Whether it always does that, big time ongoing debate. But that's the theory. That's what this branch was designed to do. Not to make the rules, but call the fouls and sometimes change how the game is played and won. Nobody likes being told what to do, but we ultimately submit to laws because we like what those rules give us. Security, order, predictability. In a lawless world, everyone's looking over their shoulder. In a lawful one, you've got a shot at building something. Our self-interest needs restraint, not because we're all evil, but because we're all human. Laws set standards. They draw a line between what's okay and what's not. Most of us have had to deal with traffic rules, for example, and thank goodness for that. Less so for criminal statutes, but we appreciate they exist because they assure a sense of predictability in our behavior and interactions. Few of us go into interpersonal conflicts with the expectation of violence because predictably few want to be imprisoned for going ham on another person. So laws help maintain order. We don't just punish wrongdoing to punish it. It's about preventing chaos from spreading. The law gives us tools, like courts, to respond, not just react. And to further limit the potential for unpredictability and disorder, laws help resolve conflicts. Settle your beefs in court, not with fists or fire. Our rights are protected by laws. Your right to free speech or a fair trial, your right to worship or your right to vote. Finally, they determine how resources are distributed, who pays taxes and how much, who gets benefits and who makes the sacrifice, and how the pie is sliced. The law shapes who wins and who loses. And just in case you didn't know, law and justice are not the same thing. Getting back to what I said earlier about justice being left wanting, we act like these concepts are the same thing, but they're not. Law is what's on the books. Justice is what's fair. They overlap sometimes, but not always. And that's where courts become battlegrounds. Don't ever forget that laws are made by political actors. They reflect compromise, pressure, and deals among human beings with varying interests. Justice, though, that's a moral question. It's about fairness and equality. And these two concepts can crash into each other. You can follow the law and still do harm. Jim Crow segregation was once the law, after all. Or you can break the law in the name of something higher, like those who fought Jim Crow segregation and were often jailed for defying it. Take a look at these examples. Legally, you can evict someone who can't pay rent after a hurricane. But does that feel just? You can also follow every rule of evidence and still convict the wrong person. Sometimes justice is delayed. Sometimes it's denied. And sometimes the law is the reason why.
I just go by what Ms. Hopkins said happened that day. I mean, I was blacked out drunk. Apparently, I was at a Publix, talking on my cell phone, and I walked up to a vehicle, leaned in the vehicle, told the person to give me the keys and get out of the vehicle. The victim said they screamed, and I walked away talking on my cell phone. I didn't want that. It's a shit, dude. Please. See, the problem was I had gone to prison for grand theft. Out of a Home Depot was a drill. Because I had been released from prison within 3 years, the state attorney offered me a 15-year plea deal, but he said, if you don't take this plea deal, we're going to enact what's called the PRR statute, prison releasee reoffender.
We could call this bill the We Really Mean It This Time bill.
People that have committed treason, murder, manslaughter, sexual battery, carjacking, robbery, arson, kidnapping.
If you have been incarcerated 3 years or less prior, and they decide to enact this statute and you go to trial, you're automatically sentenced to the statutory maximum. I was found guilty at trial. They gave me life in prison. Anything I say about the severity of my sentence, I don't mean to minimize the impact I had on her that day. She has every right to have a normal day. And so I'm sorry from the bottom of my heart.
All laws don't have the same functions. Some define what we can and can't do. Others spell out how those rules get enforced. Others apply just between you and your neighbor. If we're going to understand the judiciary, we've got to understand the types of laws it deals with. We begin with foundational judge-made law, the common law system. It's built over time through court decisions and precedent, what legal folks call stare decisis. That means if a court ruled one way in the past, future courts follow that same logic unless there's a damn good reason not to. It creates consistency, but it also means that bad precedent can hang around a long time unless someone challenges it.
Common law, rooted in medieval England, is a legal system which uses judge-made case law to bind lower courts. What does this even mean? It means the common law system uses a principle known as stare decisis, which means a higher level court will bind all courts beneath it. For example, the California Supreme Court will bind all California superior courts and courts of appeal. This is in contrast with the civil law system in use throughout most of the world. Rooted in ancient Roman law, civil law relies on highly detailed statutes to tell judges what to do and leaves little room for interpretation.
Substantive law is the what you can and cannot do. Stealing, lying on a contract, driving drunk. Substantive law tells you where the line is and defines behavior. You should know what's okay and what'll get you dragged into court, or worse. Now, procedural law is the how we apply the rules, how police conduct a search, how a trial unfolds, how appeals work. We have Miranda rights and due process and courtroom procedures. This is about making sure the system runs fairly, even when it's messy and it's slow. Criminal law deals with harm to society. You break the law, the government comes for you. Jail time's on the table. This is where the stakes are highest because your liberty is on the line. Assault, theft. This is the state saying you've crossed the line and now we're coming to collect. Civil law is more personal. It's about disputes between people, contracts, property, families. Suing your landlord is a civil dispute. Divorcing your spouse is a civil dispute, and hopefully civil. Suing a business is also a civil dispute. It's also about money and property and responsibility, not jail time. This is where most of those TV courtrooms get their content. Constitutional law is rooted in the text of the Constitution and the decisions interpreting it. Free speech, due process, equal protection, all that lives here. And the courts are, like mentioned earlier, the referees. They get the final word on what the Constitution really means in practice. Statutory laws come from legislatures, federal, state, local. These are the written laws passed by elected officials. They can be pretty broad, like the Civil Rights Act, or weirdly specific, like the fact that in Galveston, it's illegal to let your camel run loose on the beach. Yeah, that's real. Statutes can be wise, they can be dumb, and a bunch are outdated zombie laws. But once they're passed, they're law until repealed or struck down. You'd be surprised the statutory laws that are still quietly on the books from earlier, more problematic times in our history. And please don't overlook powerful administrative law. These are the barriers that govern how agencies operate, agencies like the EPA and the FDA and the IRS. These agencies write rules, they enforce them, and even hold hearings. They're like mini governments within the government. And yes, courts can review what they do. But a lot of your rights and responsibilities get shaped here, not in Congress. Finally, we've got executive orders. These come straight from the president or governors at the state level. They're directives to the bureaucracy, often with the force of law, but they can't contradict existing law or the Constitution. That's why executive orders often end up in court, because someone always asks, can the president really do that? Article 3 says there will be one Supreme Court. Congress fills in the rest. It also says federal judges serve for life and that their pay can't be cut. Now, this is because if you want judges to stand up to political pressure, they've got to be protected from political retaliation. This is what judicial independence looks like on paper, but more on that later. In the United States, we've got two court systems, federal and state. You can think of them like parallel tracks. Federal courts handle constitutional questions, federal laws, disputes between states. State courts handle just about everything else. Most criminal cases, most family law, most lawsuits. Sometimes the two systems overlap, but usually they stay in their own lanes.
So each state has its own laws and its own courts, and the federal government has its own laws and courts. And just to make it extra complicated, either court, state or federal, can enforce the laws made by the other. It can be confusing because sometimes the federal courthouse is right across the street from the state courthouse. Which one is the right one for you? The answer depends on the court's jurisdiction. Jurisdiction is the court's power to hear certain kinds of cases. The rule of thumb is that state courts have the broadest jurisdiction. It may be the opposite of what you would guess, but the state courts have the power to hear a much bigger variety of cases than federal courts. So the majority of ordinary cases are most likely to be tried in state court. State courts handle about 30 times the cases the federal court does every year, which works out to around 90% of the total caseload. But federal court will take over in special situations. For example, federal courts have jurisdiction over cases where the United States is involved as a party, and cases involving direct violations of the U.S. Constitution or federal statutes. This is called federal question jurisdiction. Federal courts can also hear cases between people from different states if it's for an amount over $75,000. This is called diversity jurisdiction. Federal jurisdiction also covers cases dealing with bankruptcy, patenting, copywriting, or maritime law. That's the ocean. However, if a state law violates a federal law or the Constitution, this can be argued in state court. But it's important to remember that federal and state court work side by side, and one is not superior to the other. Each recognizes the other's potential jurisdiction over a case.
We want to make sure we keep our terms straight to make sense of all this. So right now, we've got to talk about jurisdiction. Message. What determines whether a court has the authority to hear a specific case? 4 questions. Is the federal government involved? Are the parties from different states? Where did the dispute happen? And how serious is the issue? If it involves a constitutional right or a federal statute, you're probably in federal court. If it's your neighbor's tree falling on your car, take it to Judge Judy. Also important, original versus appellate jurisdiction. Original means the case starts here, like a trial. Appellate means the case is being reviewed, usually because someone's arguing that the lower court got it wrong. Appeals aren't about facts, they're about whether the case was applied correctly. The federal system is layered. At the bottom, you've got 94 district courts. They're like trial courts. Every state has at least one. Bigger states have more. They handle both civil and criminal cases. Then you've got 13 circuit courts, courts of appeals. These don't retry cases, they review them. A rotating panel of judges decides whether the lower court made the right call. You want to hear something wild? There are no formal qualifications to be a federal judge. None. Not age, not citizenship, not even a law degree. All you need is for the president to nominate you and the Senate not to hate you. That's it. It's all politics and power. Federal judges are appointed by the president, confirmed by the Senate, and serve for life, unless they retire, resign, or get impeached. And while the process is technically about qualifications, judges get picked for ideology, political loyalty, and payback. Them robes don't erase the politics. State courts do things differently. In the early days, governors or legislatures picked judges. By the late 1800s, most states had switched to elections because folks wanted judges to be accountable to the people. Of course, this raises the big question of whether judges should be independent or should they answer to voters. Judicial independence means longer terms, less campaigning, fewer political pressures. The idea is that judges can rule fairly without worrying about re-election. Accountability, though, means consequences. If a judge strays too far from the public expectations, they can be voted out. So which matters more, independence or accountability? That tension is still playing out today. There was this guy named Albert Kales who proposed a compromise, merit selection. A panel recommends candidates, the governor picks one, the judge serves a short term, then faces what's called a retention vote. Voters don't pick from a slate, they just say yes or no to keeping the judge. This approach tries to balance qualifications with public input. It makes selecting judges about more than a popularity contest. What you should remember is that very few states use the federal model. Most prioritize accountability. Sort of makes sense, given these are the courts closest to the people. Also, I want you to remember that the way judges are chosen shapes how they act. Are they insulated from politics or are they entangled in them? That question tells you a lot about the kind of ref you're going to get. When the framers designed the Supreme Court, they wanted it to be the least dangerous branch. It didn't have the power of the sword, like the president, or the purse, like Congress, just judgment. But judgment is everything, especially when that judgment becomes the final word. The court's power was firmly established under Chief Justice John Marshall. He wrote the opinion in Marbury versus Madison, the case that made judicial review a thing. It meant that the court can decide whether laws passed by Congress or actions taken by the president violates the Constitution. That ain't in Article 3. Marshall made that call. And with it, the court became a real check on power. Judicial review is the court's superpower. It lets them say, nope, that law is unconstitutional. Try again. And when they say it, that's it. Game over. So even though the court has no army and no budget, its power is enormous because in theory, it can stop everyone in their tracks. Where the danger lies is if one or both of the other two branches decide to ignore the court's judgment. Or the state. With no enforcement mechanism, it would expose the entire judiciary to its own form of kryptonite and probably begin the collapse of the whole system as we know it. The framework by which judges think is called jurisprudence. It's just a fancy word for legal philosophy. It's the lens through which justices interpret the Constitution and the law. This is where politics and values and worldviews creep in. Because judging isn't just about facts, it's about frameworks.
Originalism is a constitutional theory that advocates interpreting the Constitution according to its original public meaning, so that the meaning of the words were fixed at the time that provision of the Constitution was ratified, and that in order to uncover the meaning of that provision, you would try to ask, what would the average person who participated in the ratification process think this provision means? And so you can contrast that with something like living constitutionalism or its current iterations on the left, which would see the Constitution as an evolving document. So when we look at the Eighth Amendment and we look at its prohibition on cruel and unusual punishment, we don't ask, what did people in 1791 think was cruel and unusual? Because it wasn't a lot. We ask, what do people today believe is cruel and unusual punishment?
Supreme Court Justice William Brennan, in a speech today, appeared to answer Reagan administration criticism of recent Supreme Court decisions. Brennan told an audience at Georgetown University, the idea that the Constitution should be viewed as it was written 200 years ago is arrogant. Said Brennan, justices read the Constitution in the only way that they can, as 20th century Americans.
Initially, that original intent idea was aimed squarely at things that the Warren Court in particular, and to some degree the Burger Court, had done. Where's the Miranda rule in the Constitution? Well, it isn't there, obviously, not literally. Where in the Constitution is there any indication of a right to abortion? Where does it say anything about that? The promotion of these views was extremely successful.
There are three big frameworks to know: textualism, originalism, and pragmatism. Textualists stick to the exact words of the law. Originalists try to honor what the founders meant at the time. Pragmatists look at the real-world consequences of rulings. Each has strengths and blind spots, and every justice leans one way more than the others. Imagine a law says no vehicles allowed in public parks. Now, this law was passed about 50 years ago. Today, someone uses an electric wheelchair and gets fined for violating that rule. If you're a textualist, you look at what vehicle meant when the law was written. That's it. No guesswork, no empathy, just the text. But should courts ignore intent or impact just to be consistent? That's the tension. Now picture the police tracking a suspect's car using GPS for weeks with no warrant. The suspect argues it's an illegal search under the Fourth Amendment. If you're an originalist, you're asking, what did search and seizure mean in 1791? GPS didn't exist back then. So does the principle still apply? Or does sticking to the past leave us unprotected in the present? Now, let's say a state bans certain social media apps to protect mental health. Critics argue that that's a First Amendment violation. A pragmatist asks, what's the practical effect of this ban? How do we balance evolving technology with timeless rights? But the risk is if you're always adjusting for context, do you start making the law up as you go?
Old TV shows made it seem really easy to appeal to the Supreme Court, like when this lady wanted to fight her speeding ticket.
I am going to win this case. If not here, I'll appeal to a higher court. If necessary, I'll take it to the Supreme Court.
Or on Gilligan's Island, when Thurston Howell is locked in a bamboo jail and he says,
I'll take it to the Supreme Court.
But even though they make it sound like a right, nobody is entitled to an appearance at the Supreme Court. That's entirely at the discretion of the justices. And they choose very carefully. Only a small number of cases get to the Supreme Court, and it's getting smaller. Roughly 8,000 cases are submitted each year, but only 80 cases are accepted. That's a 1% acceptance rate. And to get to that 1%, most cases start at the bottom. The federal court system consists of 3 layers, and the lowest is the district level. If you lose in a district court, you can appeal to the circuit level. Most of the United States is divided into 11 circuits, but there's a 12th for D.C. and a federal circuit that mostly hears patent and military cases. Above the circuit level is the Supreme Court, the highest court in the land, as long as you don't count the basketball court that's above the Supreme Court. And to get to the Supreme Court, nearly all cases require submitting something called a petition for a writ of certiorari,
the writ of certiorari, which is shortened usually to writ of cert.
A petition for the writ of cert is a written request asking the Supreme Court to hear a case. Instead of asking the court to resolve the facts of a case, which are nearly always settled in lower courts, the reasons for granting the petition concern important questions about federal law.
The overarching goal of the court is to make sure that federal law is the same across the country. And so by federal law, I mean the U.S. Constitution and laws passed by Congress.
Professor Green clerked for Justice John Paul Stevens, where he became very familiar with cert petitions. That's because the clerks review cert petitions for their justices, who then choose to grant a petition if it passes the rule of 4, meaning that 4 justices want to hear the case. When the court does not grant cert, it does not imply a decision.
It doesn't mean that it agrees with the lower court. It doesn't mean that the individual justices agree with the lower court decision. It just means that the court has decided that this particular case is not a case where the court is going to choose to set the law for the whole country.
If cert is granted, a case probably falls into one of three categories describing most Supreme Court cases. The first is a case of national importance, such as when the court decided Bush v. Gore in order to help determine who had won the 2000 presidential election.
Drawing on very rarely used legal powers, the Supreme Court has, for the first time in American history, decided to step into a legal dispute in the midst of a presidential election.
A second type of case is when a lower court issues a ruling that invalidates federal law. An example is Gonzalez v. Raich, in which Angel Raich, a California woman, challenged federal drug laws after agents destroyed marijuana plants she had been consuming for medical use. On her appeal in the Ninth Circuit, judges ruled in favor of Raich, deciding that she was compliant with the state law authorizing her use of medical pot. But that ruling conflicted with federal law prohibiting marijuana use.
So when the Ninth Circuit said it doesn't apply, that means if you're a medical marijuana user in California, then you can use it without fear of federal prosecution. But if you are a medical marijuana user in Florida or in New York, then it's still banned under federal law.
By ruling on the case, justices were able to establish the authority of federal law prohibiting the use of medical marijuana.
In the Raich case, the Supreme Court overruled the Ninth Circuit and said that the federal drug laws can apply to local marijuana use, which means that someone like Angel Raich can still be prosecuted under federal law, even though she can't be prosecuted under state law.
Third, the court accepts cases in order to resolve a split decision in the lower courts. This happened in the case of Obergefell v. Hodges, where a Sixth Circuit ruling that banned same-sex marriage conflicted with rulings in other circuits that had upheld the right to same-sex marriage.
The Obergefell was someone living in Ohio who wanted to marry his same-sex partner and was not permitted to do so under Ohio law. It made its way to the Sixth Circuit. The Sixth Circuit said you have no right to be married because you're a same-sex couple. And that created a split, a division of authority between the Sixth Circuit, which governs Ohio, and a number of other circuit courts. And so once that happened, it was fairly clear to, I think, most legal observers that the Supreme Court was likely to hear the case because it meant that federal law, the federal Constitution in this case, applied differently in Ohio than it would in Pennsylvania, for example.
By ruling in favor of Obergefell, the court resolved a circuit split and made same-sex marriage a right nationwide. But these three categories are just a framework for understanding why the court might select a case. They are not rules. Ultimately, which cases get to the court depends on the decisions of individuals, the sitting justices of the U.S. Supreme Court.
The Supreme Court hears very few cases it's asked to review. To get there, someone files a writ of cert. Do not ask me to pronounce that full word. The writ of cert is a formal request. Then we've got the rule of four. If at least 4 justices agree to hear it, the court takes it up. That's not a majority, but it's just enough to say, this deserves a look. Outside voices can weigh in too. They submit amicus curiae briefs, Latin for friend of the court. These are legal arguments from people not directly involved in the case, trying to sway the justices. Sometimes it's scholars, sometimes it's advocacy groups, sometimes it's corporations with a lot of money at stake. These briefs shape how the court sees a case. In addition to jurisprudence, what drives judicial decisions is perhaps the idea that courts should shape policy and step in when other branches won't. That's an activist approach. Or the opposite of that is judges should stick to precedent, defer to elected officials, and not legislate from the bench. Neither is pure good or bad. It depends on who's deciding and what's at stake. Once the court decides, they explain why. That's the majority opinion. It's the official rule. But sometimes you get dissents. Justices who disagree entirely, and they want the world to know. And sometimes you get concurrences, judges who agree with the outcome, but for different reasons. Majority opinions shape how future courts interpret the law. They are the building blocks for what comes next. And they are also the blueprint for lower court judges who are making their decisions. The judiciary is the force that gives our laws teeth. It defines the boundaries of government power. and it protects the rights that might otherwise be trampled when politics gets ugly, which I don't have to tell you is often. But the judiciary is also made up of people with philosophies, backgrounds, and sometimes agendas. That's why understanding how courts work, who sits on them, how they interpret the law, and how cases get decided is essential to understanding American power. By design, the judiciary was built to be both a shield and a sword. Whether it functions that way is up to us to keep watching and questioning.